Good afternoon, everyone. I hope you can all hear and
Recording in
see me.
progress.
Okay. I think we've got some feedback there. Yeah, perhaps sorted there now. Yes, good afternoon, everyone. Welcome to this afternoon's webinar. Hopefully you can all see my screen now. Um, what we're going to be looking at this afternoon are 5 of what we consider to be the most pertinent or interesting questions we're seeing being asked by employers as we return to the office, hopefully as we come out of the pandemic and more of us move away from home working, perhaps to a hybrid arrangement or back to the office, or there will be lots of us who will continue working from home. Um, um, for those of you that don't know me, I'm Anthony Purvis. I head up the employment team here at Waterfront. Um, this afternoon, I'm going to be dealing with, first of all, how do we return to the office safely? Then my colleague, Jamie Webster, who's an associate in my team, also a specialist employment lawyer, will deal with any potential changes you might need to make to your employment contracts. He'll then look at what you can do if someone refuses to return to the office, perhaps insist that they want to continue working from home. Then I'll look at whether or not you can introduce a no jab, no job policy. Um, and finally, we'll look at a few situations and your options if an employee cannot attend work because they've got to quarantine or self-isolate. And then at the end, we'll have some questions and answers. If you do have any questions, please put them in the Q&A box rather than the chat box, and we'll take a look at the end and answer them as best we can. So let's get started. First of all, how do we return to the office safely? Well, what's the latest government guidance, first of all? As of Monday, there's no longer a government instruction to work from home, and the social distancing guidance no longer applies. The idea is that all restrictions have now been lifted. Now, in many respects, that makes an employer's job a little harder than it used to be if you employ people in an office, because until Monday, the guidance was, well, if you can work from home, then you should. And so for most businesses, most office-based businesses, it was possible to work from home, and that was the end of it. Now it's much more up to employers to decide what to do. But the legal position has never really changed over the course of the pandemic. There are 3 legal considerations. The first is that you have a legal duty to take reasonable care for the safety of your employees. Of course you do. That's found in case law, in statute. It's also an implied term of everyone's contract of employment. You have a duty to consult employees over health and safety. And if you have 5 or more employees, then you have an obligation to have a health and safety policy, to have something in writing. What does that mean in practice? 3 practical steps to be taken here. First of all, risk assessment. If you haven't done one already, they don't need to be that daunting at all. I put 2 links on the slide there. First is to some guidance from the Health and Safety Executive. You can download a template risk assessment from there. All you do is identify the potential risks and identify what you can do to mitigate them, reduce them where possible. The second link I've put on there is to some quite useful government guidance on working safely during coronavirus. If you click on that link or go to that link, there are various pages dealing with office-based environments, warehouses, restaurants, and so on. So you'll be able to find some guidance that suits your particular place of work, your circumstances, and that should be a really good assistance when you're completing your risk assessment. You then consult, and you really do that for 2 reasons. First of all, because there's a legal obligation to do it, but also because you may not know everyone's individual different personal circumstances. The risk will be different depending on age, potentially, on underlying health conditions. If you have someone with a disability, there may be an obligation to make reasonable adjustments to accommodate the effects of that disability. So it's worth consulting to see what you don't know about, what you haven't thought about, and that will help you to keep everyone safe. And then thirdly, implement. You're not going through the process of a risk assessment and consultation for the sake of it. You have to put these measures into action. And if people don't follow them, then potentially you look at disciplinary action as well. Next up is over to Jamie to talk about employment contracts.
Thanks, Anthony, and hi, everybody. So when we're looking at employment contracts in this context, really the first question we have to ask ourselves is, what is it you want to achieve? Is the intention to bring everyone back to the office full time, or to have everyone continue to work from home, or, as it seems to be quite common or increasingly common, a hybrid model where some people might work from home all or some of the time? And then the next question we have to ask ourselves is, what does the contract already say? I imagine probably lots of you will have had your workforces in the office or whatever other venue you're based in, be it a restaurant or a factory, full time before the pandemic, but that's not true of everybody. And it's relevant because you're either going to need to make a change or not. Typically, a contract will define a place of work as whatever, the restaurant or office. And it'll usually, well, quite often, it'll contain the wording that the employee must work at the place of work or such other place which we may reasonably require for the proper performance and exercise of your duties. So that flexibility is usually built in. The next question is to consider whether or not the contract has effectively been varied or changed by the conduct of you and your workforce since the pandemic started. That's an argument that might be attractive for an employee to say, well, it's been 18 months, I've been working from home. I consider that the contract's actually changed, and that our conduct over the last year and a half has meant that my home is my place of work now. Well, that might actually be a difficult argument for employees to make, because of course the pandemic's a very unusual and specific situation, and I don't think it would be particularly difficult for an employer to say, well, yes, you have been working from home for 18 months, but that's because the government has ordered that should be the case, and now that that's no longer applies, we need you back in. But you do need to consider that on a case-by-case basis. Of course, now that restrictions have been lifted, the longer that you wait before bringing your workforce back in full-time, if indeed that's what you want to do, the harder it might be for you to counter that argument by an employee. Because if you do it in 3 or 6 months' time, they might go, well, government guidance or restrictions or no, we've been working from home since restrictions lifted, and therefore you've confirmed that change has been made. Now, if you've got that flexibility in your contract that I mentioned, allowing you to have employees work elsewhere than the office or the warehouse or whatever, that's great. But these tend to be narrowly interpreted by courts. You need to be mindful of the exact wording that's in place. But if you've used the wording that I set out earlier or something similar, then that probably covers you, because if everybody's been working from home, you can say that the place of work is the office and it says so in the contract, great. But it's also useful if you want to carry on having people work from home, or indeed have a hybrid, because the some other place which you might require to the employee to work can just be their office, can just be from home. And so you can say, fine, we'll keep the place of work as it is, but we agree between us that 2 days a week or 3 days a week, or even 3 out of every 4 weeks, you can just work from home. And in fact, we're seeing lots of clients adopt that sort of hybrid model, and having their employees work 2 or 3 days a week, depending on what works for them and what works for their employees. If, however, we are looking to make some sort of contractual change, whether, for example, prior to the pandemic, you were fully office-based and you now want to introduce 100% home working, or whether you want to change from one or the other to a hybrid model, then there's a process you need to follow. And Anthony's touched on it in the first section of the webinar. The first is to ideally get consent. It's always easiest if you can get the employees to just agree to the change. You issue a letter or an email. There's no need necessarily for them to sign anything, so long as they've confirmed to you in writing that they've agreed to the change and you've communicated the change to them. The next step, if you don't get everybody's consent, will be consultation, both individually, and if you've got more than 20 people in the workforce, you'll need to do a collective consultation with the entire workforce. And then ultimately, if an employee, and we'll go into more detail on this shortly, but if an employee declines to agree the change, then what you're probably looking at is a dismissal, and that might be a dismissal by reason of misconduct if they're refusing to follow a reasonable instruction by management, or it might be a redundancy dismissal if, for example, you're closing the office and making work fully remote, and in which case you'd be saying to them, well, your workplace doesn't exist anymore, but we can offer you suitable alternative employment doing that exact job but from home. And in either case, dismissal followed by re-engagement on whatever the new terms are that you're looking to introduce. And it's worth saying at this point, actually, we're not seeing many of our employer clients having to go through that process, having to consult. Most of them are having sensible conversations with their workforce and coming to case-by-case agreements about whether people work from home all the time or 2 or 3 days per week. I'll move on to the next slide now. So some other considerations. A good practical example is a trial period, really, because it may be that you and your employees don't see eye to eye. They think that home working can work and you don't, or they'd rather not work from home and you'd rather they did. And of course, you can suggest that for 1 month, 3 months, 6 months, you give it a go. It may be during that time that you can collect enough evidence that shows that home working doesn't work, if that's the way around the situation is, or indeed, you might be persuaded of their position. You might go, actually, that works really well. We're going to keep you working from home, or actually some issues with you working from home have arisen that we haven't considered, and maybe we'll keep the office open a couple of days a week. If we're actually making changes to the contracts, there are certain things that we need to make sure are included in there. So the first, which we've sort of touched on, is a right to return employees to the office as and when you might want them to, and that's if you're going for work from home as a standard. Again, that wording I mentioned earlier covers that situation. So if you're in the position where you've got that flexibility, fine, no change needed. Another consideration is that you need to make sure that your employees aren't restricted from working from home. It may be that they're party to an insurance policy or a lease, perhaps a mortgage loan agreement, or even restricted covenants over the land on which their house lies. And any of those documents might contain a restriction from carrying out work in their home. So that you need them to confirm in your contract that that's not the case. They're not in breach of any other obligation by working for you from home. Health and safety is obviously a big important point. Now, ideally, you'd want a right to inspect their home office, but perhaps that might be intrusive. It might also be an expense you don't want to incur, having you or someone, one of your workforce, go out and inspect people's home offices. You can probably achieve the same thing by having employees fill out a questionnaire or requiring them to comply with reasonable requests for information, evidencing that their home office complies with health and safety. Confidentiality and security of information is another point that I think is fairly trite to say that homes tend to be less secure than offices. You're unlikely to have a swipe card going in and out of the room in which you work, and probably a lot of people share their homes with spouses or kids or housemates. And so it's important to make sure that there's a guarantee in the contract that employees should try and replicate the security of an office as much as possible. So that means locking their computer when they're not at it. If there's any confidential documents or information, you don't want those to be lying around where anyone else in the house or visitors to the house might see them. And so perhaps a locked drawer would be appropriate. And there's also, of course, a data protection aspect to the confidentiality and security point, which is that your employees may or may not be processing data on your behalf. And it's important to make sure they're doing that in the right way. For example, you don't want a document with someone's personal data lying in a drawer at someone's home office for 3 years, when you might have obligations about destroying that data after a certain period of time. And you may also consider updating your expenses policy. If, for example, you're keen to reimburse employees for their internet use or their power, given that they're not using the office to be online, but they're using kit they've got at home. And so that's something to consider. And then lastly on this point, It may be that you can achieve some or all of this without needing to change the contract, and just by changing your staff handbook or your employee policies. And that, of course, is an appealing option, because whereas there's the duty, well, whereas you may need to get consent or consult to change the contract, typically that's not the case with a staff handbook or with your policies. Those tend to be flexible enough that you can change them on a whim. But of course, it's worth checking what the contract says and whether these issues are raised by that. Moving on to the next slide. So what happens if someone refuses? Someone declines a change in their terms and conditions, or they just say, no, I'm not coming in. Well, most important thing is, what's the reason for their refusal? As there's any number of reasons why they might refuse, and that'll, depending which one that is, it'll depend on whether they can get away with saying that, and what your options are as an employer. For example, probably the most obvious one is if an employee is disabled. What reasonable adjustments might be able to be made if they say that because of their disability, they are not able to return, or they don't want to return to the office. It may be that with some reasonable adjustments, you can make that viable for them and have them come back in. Now, if the employee lives with a disabled person and they refuse to return on that basis because they're concerned about the impact that them returning to the office might have on their spouse or their child or person with whom they live who is disabled, there is a duty there for you not to directly discriminate, harass or victimize that employee because of their close relative or cohabitant's disability. But there's no duty to make reasonable adjustments on account of that other person, that third party's disability. Nor are you prevented from discriminating because of something arising from that close relative or cohabitant's disability. Indirect sex discrimination is another thing to consider. Statistically, female employees are more likely to have childcare responsibilities, although of course not all will, and are therefore more likely to be impacted than male employees by a policy of bringing everyone back into the office, if that female employee indeed has childcare considerations. So they may well argue that blanket policy is to their detriment to a greater extent than it is to a male colleague, and that therefore that's indirect sex discrimination. However, maybe you've got a lawful justification for bringing them into the office, and that's something that's worth applying your mind to. Just because there may be a prima facie case of indirect sex discrimination doesn't mean that you would lose that case. You may be able to justify the discrimination. Of course, what the current public health guidance and advice is going to be relevant. Currently, as Anthony mentioned, there's no requirement to work from home, and there are no social distancing rules. But of course, this may change over the coming months. We've seen cases and hospitalizations rise. None of us know what the government may or may not do over the coming months. And so, as I'm sure we all have been, it's important to keep on top of that because that may impact on your duties or your obligations or the options available to you as an employer. Is furlough a solution? Maybe. I'll just read a small portion here from the documentation underlining the scheme itself. So the purpose of the CJRS, the furlough scheme, is to provide payments to be made to employers on a claim made in respect of their incurring costs of employment in respect of furloughed employees arising from the health, social and economic emergency in the United Kingdom resulting from coronavirus and coronavirus disease. So if your employee is prevented from working, perhaps because your workforce is all having to self-isolate, they've all been pinged by the app and you've had to shut down, probably that's covered by the furlough scheme. That's a reasonable claim to make. What it's not for is my employee wants to continue to work from home, but are perfectly able to come in, and I'll fudge it by putting them on furlough. Or at least I would advise, looking at that in detail and perhaps taking advice in those situations, because you don't want to run afoul of, an improper claim under the furlough scheme. And then lastly on this slide, is it appropriate to discipline for a failure to follow a reasonable management instruction and indeed to undertake unauthorized absence? Well, I've touched on this a little bit. Yes, probably, but subject to all of the above. So on a case-by-case basis, if you're sure that there's no disability discrimination, sex discrimination, there's no sort of valid reason in the law why someone could insist on working from home, then yes, it is probably reasonable. You have to go through the normal disciplinary process, an investigation, a disciplinary hearing, depending on the severity of the offence, dismissal may not be the appropriate sanction. So all those usual things apply, but you do need to look at it on a case-by-case basis. And I'll go on to the next slide, which deals with a particular type of claim that's increased in prevalence over the last 18 months for reasons which hopefully will become obvious. Section 44 and 100 of the Employment Rights Act 1996 protects an employee from detriment or dismissal where that employee reasonably believes that they're in serious and imminent danger in the workplace and that they couldn't be reasonably expected to avert that danger. And as a result, they leave, propose to leave, or refuse to return to their workplace whilst that danger persists. And importantly, the employee also has to have taken or proposed to take appropriate steps in the workplace to protect themselves or other persons from the danger about which they are concerned. Unlike an ordinary unfair dismissal claim, an employee doesn't need 2 years service in order to bring a claim like this. And I think there's certainly some concern among employers early in the pandemic that this was going to be a sort of a free pass for employees to say, well, there's a pandemic on, I couldn't possibly come in, regardless of whether any requirement to work from home was in legal force. And whilst 18 months might seem like a very long time, and I think it does to all of us in some senses, in the world of the employment tribunals and case law decisions, it's not very long at all. And so unhelpfully, we don't really have any binding Court of Appeal or Supreme Court decisions that assist us in this respect. What we do have is Rogers and Leeds Laser Cutting Limited, which is a first instance tribunal decision. So it's just an employment tribunal that heard this case, and so it's not binding anywhere else. But it is useful in a number of ways in indicating how tribunals might look at these sorts of issues and the particular scrutiny they're going to apply both to what employers do to make workplaces safe and to an employee's claim that they don't feel safe going in. So Mr. Rogers, in this case, messaged his employer to say he had a child with sickle cell, a vulnerable child, and a new baby who may well have health vulnerabilities they didn't know yet because it was a newborn, and that he wouldn't be returning to work until the lockdown has eased. A month later, he was dismissed, and that dismissal was ultimately held to be reasonable. And Mr. Rogers' claim for unfair dismissal under Section 44 and 100 failed. Now, as is often the case, this case turned on the specific facts. When it came to witness evidence in the hearing, Mr. Rogers didn't actually appear to believe he couldn't work safely. He hadn't mentioned any specific workplace dangers or taken any steps to avoid danger in the workplace. He'd not criticised anything about his employer's approach to workplace safety in the pandemic. He'd simply said, I'm not coming in until the lockdown has eased. There was some suggestion he'd worked in a pub during lockdown and had driven a friend of his to hospital during the first lockdown, during the period where he'd said he wouldn't be coming in. And he even conceded at one point that social distancing was perfectly doable. So perhaps didn't help his case there. It's also very important that his employer in this case had carried out a full risk assessment and had gone to some steps to make the workplace safe, both in terms of sanitizing and cleaning surfaces, implementing staggered start times and social distancing. And so this case shows the importance of taking those steps, of demonstrating appropriate health and safety, because if you end up in a tribunal, those are the questions that the tribunal is going to ask. And if you can show that you've taken reasonable steps, then it may be you can defend a claim of this kind. And really the steps that this company took helped contribute to the tribunal's conclusion that Mr. Rogers' belief was not reasonable, because of course there's two limbs to his belief. There's two aspects of him showing he believes it's unsafe, and indeed any other employee. Number one is that they reasonably believe they're in serious imminent danger. But the other aspect of that is that belief has to be objectively reasonable. It doesn't matter how sincere the belief is if it's manifestly a silly thing to believe. And so if Mr. Rogers had ticked all the right boxes, he might have succeeded. And of course, this is where the employer's risk assessment, which Anthony's touched on, is very important. And that's, of course, something that we at Waterfront can assist with if needed. As I've said already, the current status of the pandemic, hospitalizations, case rates, and deaths will be relevant to that objective assessment of whether an employee's belief is reasonable. And the key thing about this case, which I think will reassure many employers, is just the fact of the virus being in circulation and there being a pandemic is not itself sufficient for an employee to go, well, I'm not coming into the office until the pandemic's gone. And then lastly on this slide, the sole or principal reason for the dismissal, which potentially gives rise to a claim of this kind, must be that the employee took or proposed to take the steps of removing themselves from the workplace. So if you're dismissing someone and that's one of the aspects, but there are other reasons for the dismissal, that might too be fatal to a claim of this kind. Thank you very much. I'm going to pass back to Anthony now to talk about no jab, no job, a topic about which you perhaps have read.
Thanks, Jamie. Yes, no jab, no job policies rolls off the tongue quite well. It's also a bit of a headline grabber. You may have seen that Charlie Mullins, the boss of Pimlico Plumbers, decided to make headlines for his business back in January when the vaccination program was just started. He said, everyone who works for me, everyone who works for me will have to have the jab. I'm actually going to answer a slightly different question, although if you do want to corner me on no jab, no job, feel free to put a question in the Q&A or catch me afterwards. But I'm going to answer a slightly different question, and that's, can I require only vaccinated staff to return to the office? That's the question we're seeing much more frequently. We're not really seeing employers saying no jab, no job. So can you have only vaccinated staff return? Short answer is yes, probably, but there are some risks, and ultimately you need to weigh those risks against your health and safety obligations, and also against the commercial desire or the pressure that there is to roll out such a policy. What are the risks? Well, there's the potential for discrimination. Perhaps not everyone can comply with such a policy. And I've said there, against those who are young, disabled, pregnant, trying to conceive, or potentially hold certain religious beliefs. It's interesting how quickly the position and the advice in this area can change, because I was working with a client a month or two ago and discussing such a policy. And I said, well, aren't a lot of your employees young, or young enough that they won't have had their jab yet? At the time, I think they were asking people in their late 30s to come forward. And now everyone can get their jab if they want. So maybe that age discrimination angle falls away. I also say to clients, look, this policy of having only vaccinated staff in is attractive, I get that. But it's only one way of reducing the risk to employees. It should really only be one line, one aspect of your risk assessment. I don't think we know how effective it is at reducing transmission, the vaccination, and it doesn't allow you to stop cleaning, screens, distancing, ventilation, staggered starts. These are all tools that you should be using still to reduce the risk. There are also some data protection considerations, which I'll come on to on the next slide. But in short, the best practice at the moment appears to be a policy of encouraging your staff to take the jab, to have the jab, and encouraging them to do so before they return to the office, and consulting, listening to those who might have a problem with that, rather than just steamrolling in with a mandatory policy. Even if there is a discrimination claim or someone who is unhappy, well, what's your fallback position? Well, they can probably continue working from home if they have for the last 15, 18 months or so, at least in the short term anyway, until hopefully the risk falls away even more so. Data protection, potentially huge topic. We could fill a whole webinar on this as well, but I just want to flag the basics. health information is special category data, so you need to hit a higher threshold in your reasoning for processing it. You need both the legitimate interest, which you probably do because you have a legitimate interest in complying with your health and safety obligations. And then you need something else, and there's a list of about 10 or so reasons. And two are likely to be the most relevant. You either need consent from the individual to process it, or you need to show that it's necessary to process it for performing certain legal obligations. Now, both sound viable, I suppose, but the ICO Information Commissioner's Office guidance indicates that both can be problematic, and that's because consent is rarely appropriate, they say, in an employment context because it's not freely given. There's that inequality in the relationship, so consent should be freely given, and it's hardly ever done so in an employment setting. And also, there's a question mark over whether or not it's necessary for an employer of office-based staff to process the information. I'm conscious we're focusing very much on office-based staff in this webinar. That's deliberate because a lot of our clients work in offices. But the ICO points out that, well, it might be necessary for someone who employs people in a care home, but less so for office-based. So there are some question marks over the data protection aspects. And as I said, it's about balancing the risk against the reward, as it were. An interesting case study is that of JP Morgan, who are in the news because they were requiring all their US staff to disclose their vaccination status, but specifically not their UK and EU teams. And they cited the data privacy laws in the EU and the UK and the complications that arise from that. Finally, then, we're going to look at what are the options if an employee is required to quarantine and cannot attend work. And I pose this question because it's one that I think is going to be asked more and more frequently as we have this system of people starting to go on holiday, especially as we're just about to break up for the school holidays, and countries coming in and out of green and amber or amber plus all the time, it seems, and potentially people getting caught out. First of all, if you're self-isolating, then working from home might be an option, should be an option for many, many people. If not, then statutory sick pay is payable under the amended SSP regulations, which were changed by the government quite early on in the pandemic to recognise that if you are self-isolating, you're not off sick, you're not perhaps sick at all, so you're not otherwise caught by the rules on SSP. But they changed the rules so that SSP is payable in those circumstances. And there's more to it than this, but there's a summary there of when it's payable. It's when you're known or reasonably suspected to be infected or been in contact with an infection. But what about if you're isolating upon return from holiday and cannot work from home? There are various permutations of how this situation might play out. We were talking earlier about the person who goes on holiday knowing full well there's going to be a problem when they get back. Hopefully those cases are few and far between. But ordinarily, if someone doesn't work, they don't get paid. But that's not the end of the answer. There is some case law to suggest that where there's a third-party constraint preventing you from working or makes the inability to work involuntary, it's an exception to this rule. So it's not as clear-cut as it could be if someone is hamstrung from working because of government restrictions. As I touched on earlier, if someone has booked a holiday knowing full well they're going to have problems when they get back, then that's likely to be a misconduct matter. The trouble is as well that in that situation, You're probably not caught by the definition, the amended SSP regulations. It's probably a stretch to show that, or to say that you're requiring to quarantine or self-isolate when you're coming back from holiday because you're known or reasonably suspected to be infected. That's probably a bit of a stretch. And I think, like with a lot of these questions, the answer is going to vary on a case-by-case basis, but discuss it. Assess what the options are before coming to a decision. Could the employee take further holiday to cover themselves for the isolation period? You'd have to agree it with them. There wouldn't be sufficient time for you to give statutory notice for them to take holiday. But yeah, there are a number of options you could use there. Okay, now we're on to Q&A. So I'm just looking at the Q&A for the first time. If you've got any questions, do pop them in there. Let's see, we've got one attendee who asks, what might a reasonable adjustment look like if an employee is disabled? I suppose that's a really common question. What do we mean by reasonable adjustment? And it's not particularly helpful to say, well, whatever is reasonable in the circumstances. But the obvious reasonable adjustment we have in most cases, if someone can't come into the office for a disability related reason, and they've been working from home for the last 18 months or so, is to continue that. That seems an adjustment which would mitigate the impact their disability has. And it's reasonable. Well, it's worked well enough, probably, for the last year or so. So it's probably reasonable to extend it, not necessarily indefinitely. One would hope that the situation is such that it's no longer reasonable or necessary for someone to stay at home. And as always with reasonable adjustments, talk to the individual, discuss what the problem is, how they might be able to do their job or be offered support to do their job. And then there's another question here around, is a no jab, no job policy actually viable? So catch me out there for dodging the question, quite rightly so. I think the reason we're not really seeing that sort of policy, other than people like Charlie Mullins wanting to make millions of pounds worth of free publicity for their businesses, is because it's probably too difficult in practice. I've already touched on some of the complications, but I think a further complication is when you want to introduce that for your existing workforce. Say you have several people, tens, hundreds of people, and many of them have unfair dismissal protection, contractual rights, and so on. It's going to be difficult, I think, to roll out that sort of policy in practice to your existing workforce. Not impossible, and if anyone's up for it, let's go for it. But I'm yet to hear of any of our clients who want to give it a go. Okay. We were intending to speak for just half an hour, so we're about 10 minutes over. I think we will leave it there then. Thank you all for attending. Hope you enjoy the rest of your day. Don't get too hot in the hot weather. And thank you. Goodbye.
Thanks, everyone.